Now, the American Supreme Court has ruled against the American President Donald Trump's global tariffs, marking a major setback for executive power in trade policy. The top court has said that the tariffs were enacted under a federal law that was meant for national emergencies. The White House has offered no immediate response to the Supreme Court ruling. Donald Trump has labeled it a complete disgrace just moments after learning of the decision during a meeting that he was having with the governors. Now, more than $175 billion in terms of U.S. tariff collections are now at risk of having to be refunded. Importers are expected to scramble for refunds from the U.S. Customs and Border Protection Agency on import duties paid over the past year. And these tariffs, which are enacted under the International Emergency Economic Powers Act, have prompted some extensive litigation and debate over whether a president can levy these broad import duties without explicit congressional authorization. Now, Trump has also touted the revenue generated by all of his tariffs, estimated by the Congressional Budget Office at about $300 billion annually over the next decade. But the estimates show that a substantial amount may need to be refunded if the court rules against Donald Trump.
Good to see you. Welcome to Dr. John Podcast. The Supreme Court, in a 6-3 decision authored by Trump's own appointee, Amy Coney Barrett, ruled that the International Emergency Economic Powers Act does not give the president the broad tariff authority the administration had been claiming, effectively dismantling the legal vehicle for Trump's unilateral global trade policy. The ruling, joined by Chief Justice Roberts and Justice Gorsuch, was a devastatingly clear check on presidential power from the very institution Trump thought he had in his pocket. But the real story here isn't just about the ruling itself, it's about how Trump responded to it. And that response was absolutely nuclear in its intensity.
Now, after the Supreme Court ruling, refunds of $175 billion will exceed the combined fiscal 2025 outlay from the Department of Transportation at $127.6 billion, and also the Department of Justice at about $44.9 billion. Now, these tariffs imposed by the American president have affected many countries across the boards with different rates. For instance, India, after a tariff deal, has got 18%. Indonesia has 19%. Pakistan has 19%. Bangladesh at 19%. China currently has 37% tariffs. The EU has managed to get a 15% deal. Vietnam has gotten a 20% deal. And Brazil has a tariff of 50%. Now, importers from these nations have paid duties that could now return to them through claims processes. The legal teams are preparing the next steps as the government is assessing compliance. Markets are monitoring the effect on trade flows and federal budgets ahead. But the question now is, of course, this: what are Trump's other options? He can still wield tariff authority through Section 232 of the Trade Expansion Act of 1962. Now, the act targets national security threats, and Section 301 of the Trade Act of 1974. That is aimed at unfair trade practices.
Standing at that podium in the White House briefing room, Trump didn't deliver a measured statement acknowledging the court's authority while expressing disagreement through appropriate channels. That's what normal presidents do when they lose at the Supreme Court. Instead, Trump went straight for the personal attacks. He called the ruling deeply disappointing. He said he was ashamed of certain justices. He named names and expressed his fury in ways that would have been unthinkable from any previous occupant of the Oval Office. The personal nature of these attacks was stunning to watch, even for those who thought they'd seen it all. And then came the move that revealed everything about how the administration assesses constitutional constraints.
All right, and our correspondent Susan Tehrani is joining us from New York. She's, of course, tracking all the developments as they are unfolding at this moment. Susan, this is a critical moment in Donald Trump's presidency. One of his pet projects that he was using, these tariffs, to try and get more leverage with nations that he was dealing with, has now been struck down by the American Supreme Court. Tell us what happens from here on.
Right. So basically, the justices ruled that it is Congress that has power of the purse. And at the end of the day, they did not buy President Trump's justification and his administration's justification in using this 1977 Emergency Act. They said at the end of the day, tariffs are taxes, and that goes straight to Congress to decide. Moving forward, we'll have to wait and see how fast Congress wants to decide, or whether or not they will sort of have a mandate and codify tax laws for the Trump administration and these tariffs to move forward? Or are they going to stand back and watch the Trump administration use its other tools in its toolbox? I think it's important to note that while the justices did rule on this, and it is a huge setback, it doesn't mean that tariffs are illegal. It means presidential authority has to be limited. On limits of presidential authority was the opinion that was discussed in using these emergency laws for these tariffs.
Before the press conference was even over, Trump announced that he was signing a new 10% global tariff order under a different statute immediately, right then and there. Not next week after careful legal analysis, not after consulting with attorneys to find the best alternative approach. Right there at the podium, in the same briefing where he was attacking the justices who had just ruled against him, Trump announced his workaround. The message could not have been clearer. The administration was not going to allow the legal constraint to stick. If the Supreme Court said one legal authority was off the table, they would simply find another one and keep moving forward.
But there's a lot of questions remaining. While there is celebration among small businesses, and the Democrats have been celebrating on Capitol Hill, senators and Congress members have all said that this is a welcome note for the Americans. It's not yet clear how they need to adjust at this point, how much of this money needs to be returned, and most of all, whether or not it's going to be in a limbo for months or years, or is this litigation just going to fall apart and the Trump administration is going to, start a new cycle. So there is a lot of uncertainty, but for now, at least, it seems that the Democrats and businesses are celebrating. And I can tell you China is celebrating right now as well.
Thank you very much, Susan Tehrani, for joining us and getting us all those updates. We'll, of course, come back to you as this very crucial story continues to unfold in the United States of America. One of Donald Trump's pet projects, to use tariffs to try and push forth his foreign policy. Is there going to be a change with respect to how Trump will operate at the White House from here on? To put things in perspective,
this immediate reflexive response communicates something profoundly important about how this administration processes constitutional constraints. When the Supreme Court says no, the reaction isn't acceptance. It isn't recalibration. It isn't a respectful acknowledgement of the constitutional architecture. It's immediate workaround. It's finding the fastest available route around whatever obstacle the court has placed in front of them. And the message this sends to the court, to Congress, to the markets, and to international trading partners watching this unfold is unmistakable. The administration will not allow legal constraints to stick if any alternative mechanism can be found and deployed at speed. Now let's talk about why this specific ruling hit so hard and why the freakout was so genuine and so intense. To understand the nuclear quality of what just happened, you have to understand what IEEPA actually is and what the administration had been using it for. The International Emergency Economic Powers Act was passed back in 1977 as a framework for presidential economic responses to national security emergencies. It gives the president broad authority to regulate international commerce and financial transactions after declaring a national emergency. Sounds reasonable enough, right? A tool for responding to genuine emergencies. But the Trump administration's use of IEEPA represented something far more ambitious than anything the statute had ever been applied to before. The administration claimed that the president's ability to regulate international commerce under IEEPA extended to imposing sweeping across-the-board tariffs on imports from dozens of countries simultaneously. These tariffs were massive in scale and scope, effectively reshaping the entire global trading system through unilateral executive action. The legal theory underlying this claim was that the president's emergency powers allowed him to exercise the specific constitutional authority that Article 1 assigns exclusively to Congress, the power to lay and collect taxes on imports. In other words, the administration was claiming that an emergency declaration could effectively transfer the constitutional taxing power from the legislative branch to the executive branch. That's not a modest extension of established authority. That's a breathtaking assertion of presidential power with profound constitutional implications. The court's rejection of that claim is a rejection not just of the specific tariff orders at issue, but of the broader constitutional theory that emergency declarations can authorize the executive branch to exercise powers that the Constitution specifically assigns to Congress. This is a constitutional statement with implications that extend far beyond trade policy. If the president can use an emergency declaration to exercise Congress's tariff power, what other constitutional powers could be claimed through the same mechanism? The taxing power, the spending power, the power to declare war. The line that the court drew at IEEPA's limits is a line that constrains the entire theory of emergency presidential power. Now here's the element that makes this ruling truly nobody-saw-coming territory: the specific composition of the 6-3 majority. Chief Justice Roberts, Justice Gorsuch, and Justice Barrett. 3 justices with conservative legal credentials. 3 justices with documented records of support for executive authority in multiple other contexts. 3 justices who sit on the court because of Trump's own nominations. They joined the 3 liberal justices to produce a supermajority rejection of the IEEPA tariff theory. The administration had been winning on the emergency docket at extraordinary rates. They had received significant accommodation from the court on immigration enforcement, on agency restructuring, on workforce reductions. There was a specific expectation, one that was not unreasonable given the pattern of emergency docket wins, that the court that had been so consistently accommodating would also validate the underlying legal theory when the merits were finally addressed. But the emergency docket accommodation turned out to be something very different from Merritt's endorsement. The court allowed policies to proceed while litigation continued, but when the underlying legal question finally came before it, the court found that those policies lacked the statutory foundation they claimed. That distinction between emergency docket accommodation and Merritt's validation is the legal reality that the nobody-saw-coming framing is accurately describing. The administration had been winning so consistently on the emergency docket that they had come to believe the substantive legal arguments would eventually prevail as well. They were wrong, and the shock of that discovery produced the freakout we witnessed in that briefing room. The immediate announcement of a new 10% global tariff under a different statute reveals something else important about what just happened. The administration didn't take a few days to assess the ruling and identify a measured alternative approach. They announced an alternative immediately, publicly, in the context of the press briefing where Trump was personally attacking the justices who had just ruled against him. This specific combination, personal attacks and immediate alternative announcement, communicates the administration's response to constitutional constraint in the most direct possible way. Not acceptance, not recalibration, immediate workaround. The court says no, we find another way. The constitutional principle that the ruling established does not matter as much as the policy outcome that the administration wants to achieve. The split among Republicans in response to the ruling is itself one of the most significant political data points that the ruling generated, and it reveals something important about the constitutional landscape within Trump's own political coalition. Some Republicans, like Representative Buddy Carter, characterized the ruling as judicial overreach that undermined Trump's ability to protect American workers. Others, like Senator Rand Paul and Representative Don Bacon, praised the ruling as a constitutionally appropriate defense of Congress's specific assignment of tariff authority. This split reflects a real and pre-existing tension within the Republican constitutional worldview, a tension between the desire for strong executive action that serves the MAGA policy agenda and constitutional textualism that has long been the theoretical foundation of conservative legal thought. The tariff ruling put that tension into sharp relief because the specific constitutional provision at issue, Article 1's assignment of tariff power to Congress, is not ambiguous. The Constitution says Congress has the power to lay and collect duties. The administration was claiming that an emergency declaration under IEEPA gives the president the authority to exercise that power without Congress. The justices who rejected that claim, including 3 Trump appointees, were applying the constitutional text as written rather than deferring to the administration's preferred reading. That is the specific constitutional moment that produced the Republican split and that the nuclear move framing is trying to capture as the moment when the constitutional architecture finally pressed back against the administration's most expansive emergency power theory. The broader pattern of emergency power claims that the ruling is pushing back against is the administration's consistent use of emergency declarations to accelerate the implementation of policy goals that would otherwise require the slower legislative process. The tariff case is the most prominent and most economically significant example of that pattern, but it is not the only one. The administration has used emergency authority claims across multiple policy domains: immigration, energy, regulatory authority, in ways that critics have argued amount to a systematic attempt to govern through emergency declaration rather than through the legislative process that the Constitution requires for most major policy changes. The court's specific finding that IEEPA does not authorize the sweeping tariff authority the administration claimed is a targeted rejection of one particularly significant emergency authority claim, but it establishes the principle that emergency declarations are not blank checks for presidential policymaking. Let's really dig into the legal reasoning behind this ruling and understand why it matters so much beyond just the specific tariff authority that was eliminated. The court's finding that IEEPA does not authorize sweeping tariffs rests on a specific interpretation of what the statute's text actually says and what the historical context of its enactment establishes about what Congress intended it to authorize. IEEPA's language gives the president authority to regulate or prohibit transactions. On its face, that sounds like a broad grant of regulatory authority over international commerce. The administration's argument was that this regulatory authority encompasses the ability to impose tariffs to tax imports because tariffs are a form of regulation of international trade. Seems logical enough on the surface, right? But the court's rejection of that argument is grounded in a crucial constitutional distinction: the distinction between regulation and taxation, between the executive branch's regulatory authority and the legislative branch's taxing authority. The specific power to lay and collect duties is assigned to Congress in Article 1, Section 8, a statute that grants the executive branch broad regulatory authority over international commerce does not, in the court's interpretation, implicitly grant the authority to exercise the specific constitutional power that Article 1 assigns to Congress. That is the constitutional line that the IEEPA tariff claim was crossing. And it is the line that the 6-3 majority drew at the point where the administration's regulatory authority claim became a claim of legislative taxing authority. Now let's talk about what this ruling actually means in practical terms for the Trump economic agenda. The sweeping global tariff regime that Trump had implemented through IEEPA was the economic instrument through which the America First trade agenda was being implemented in its most aggressive form. It applied simultaneously to dozens of countries. It covered broad categories of imports, and it was implemented at a speed and at a scale that the ordinary process of negotiating tariffs through the legislative or regulatory process could not possibly match. The administration could essentially reshape the global trading system overnight through executive action alone. That level of unilateral power was unprecedented in American history. The loss of that instrument, the specific legal authority to impose sweeping across-the-board tariffs through an emergency declaration, forces the administration into a much more constrained position. They can either use the narrower statutory authorities that remain available, which have shorter sunset provisions and more limited scope, or they can pursue the legislative route that requires congressional cooperation. Neither of those alternatives provides the speed and the unilateral flexibility that the IEEPA emergency authority provided. The court has, in specific and practical terms of trade policy implementation, made it significantly harder for the administration to pursue its most aggressive trade policy objectives through unilateral executive action. That's a huge practical consequence that will be felt in real economic terms. And the markets noticed. The market's reaction to the ruling and to the administration's immediate announcement of an alternative tariff mechanism was itself a significant data point about the economic consequences of this constitutional confrontation. Markets had been watching the tariff situation closely throughout the period when the IEEPA orders were in effect and being challenged in court. The specific uncertainty created by the legal challenges, the question of whether the tariff authority would ultimately be sustained, had been a factor in the market's assessment of the trade policy environment. Now the ruling eliminated the IEEPA tariff authority, followed immediately by the administration's announcement of a new order under a different statute with a shorter statutory window. That created a specific and complex set of signals for markets to process. Signals about the legal durability of the alternative mechanism. Signals about the administration's intent to maintain the tariff pressure regardless of legal obstacles. Signals about the longer-term trajectory of the trade policy confrontation. The nuclear move framing is reaching toward the quality of that specific market moment. The overnight reconfiguration of the trade policy legal landscape in ways that market participants had to immediately begin assessing and pricing. This isn't abstract legal theory. This is real economic consequence playing out in real time. The Republican split over this ruling deserves deeper examination because it represents a genuinely important constitutional debate within the Republican coalition that the ruling has forced into the open. For decades, the conservative legal movement has championed the principles of constitutional textualism and originalism as the correct approach to constitutional interpretation, the approach that applies the Constitution's text as written rather than expanding its meaning through judicial construction to accommodate preferred policy outcomes. Those same principles applied to Article 1's assignment of tariff power to Congress support the court's conclusion that IEEPA does not authorize the president to exercise that specifically assigned congressional power through an emergency declaration. The conservative justices who joined the ruling, Roberts, Gorsuch, and Barrett, were applying the textualist principles that have been the foundation of conservative constitutional thought to reach a conclusion that limited rather than expanded executive power. The Republicans who attack the ruling as judicial overreach are in the position of defending executive power expansion against the very constitutional methodology that conservative legal theory has championed. This tension between the policy preference for strong executive authority and the constitutional methodology that the same political coalition has used to argue against judicial activism is the specific internal contradiction that the ruling has exposed within the Republican constitutional worldview. And it's a contradiction that's going to be very difficult to resolve. The administration's freakout response, the personal attacks on named justices, the immediate announcement of an alternative mechanism, the characterization of the ruling as a disgrace, is itself constitutionally significant as a data point about how the executive branch is processing judicial constraint. Previous administrations that received adverse Supreme Court rulings typically responded with measured public statements that acknowledged the ruling, expressed disagreement through appropriate legal and political channels, and committed to working within the constitutional framework the ruling established. The Trump administration's response to the IEEPA tariff ruling did none of those things. It attacked the justices personally. It announced an immediate workaround, and it characterized the exercise of the court's core constitutional function, interpreting a statute to determine what it actually authorizes as a disgrace. That response communicates something specific about the administration's relationship to the constitutional architecture of checks and balances. A relationship in which constitutional constraints are not legitimate limits to be respected, but political obstacles to be routed around as quickly as possible. And the court, which is watching the same behavior that everyone else is watching, processes that communication in the cases it subsequently decides. The long-term implications of this pattern of behavior for the court's willingness to accommodate the administration's emergency power claims are going to be significant. Now, the nobody-saw-coming quality of this nuclear move is worth examining as a claim about the political and legal expectations that preceded the ruling, because the specific element of surprise is one of the most politically significant aspects of the decision. The administration had won on the emergency docket at rates that legal analysts described as extraordinary. It had received significant accommodation from the court on multiple policy fronts. The specific justices who joined the 6-3 majority, the three Trump appointees, have been described in political commentary as reliable votes for executive authority in the context that most directly matter to the administration. The surprise of their votes against the IEEPA tariff authority is the specific element that makes the nuclear framing most apt. The specific quality of a development that nobody in the political or legal world fully anticipated in the form it took, arriving as a completed fact in a 6-3 majority opinion that left no room for the qualified endorsements or the narrow rulings that a more cautious court might have produced. When the court strikes with that kind of decisiveness in a direction that the administration did not expect on a question that matters as much as the tariff authority does, the nuclear move framing is not hyperbole. It is the most accurate single term for the specific quality of the surprise and the scale of the consequence. This wasn't a procedural loss that could be appealed or a narrow ruling that left room for future arguments. This was a decisive, complete, and unexpected rejection of one of the administration's most powerful governing tools. Think about what it means when the Supreme Court tells the most powerful person on earth that one of his most important policy tools is gone. Not limited, not restricted, gone. The legal authority simply does not exist, and 3 of the justices who delivered that message were put on the court by the very person they just ruled against. That's not a defeat that can be easily explained away as partisan bias or judicial activism. That's a defeat that comes from the court's own conservative wing applying constitutional principles to constrain executive power. And that's why the freakout was so genuine and so intense. The administration had no one to blame but the constitutional framework that it had spent years trying to reshape. What the IEEPA tariff ruling ultimately represents in the broader constitutional story of the Trump second term is the specific moment when the constitutional architecture's most important defensive mechanism, the Supreme Court's power to say what the law is and to find that executive branch claims of authority exceed what the law actually authorizes, demonstrated its capacity to function at the highest levels of constitutional confrontation against a president who was genuinely surprised by and genuinely furious about the constraint. The court said no. 6 justices said it. 3 of them were there because of Trump. And the emergency authority that had been one of the administration's most powerful governing tools was gone. That is the nuclear move. That is the nobody saw coming quality. And the freakout that followed, the press briefing attacks on the justices, the immediate alternative announcement, the characterization of the ruling as a disgrace, is the most accurate description of the presidential response to a constitutional development that the administration genuinely did not expect and cannot fully absorb into its public narrative of unconquerable executive strength. Now let's bring this all together and understand what this ruling means for the long-term trajectory of the Trump governing approach and for the constitutional principles that will govern executive power going forward. Because this isn't just about one ruling on one issue. This is about the fundamental relationship between the executive branch and the judiciary, between presidential power and constitutional constraints, between the desire for unilateral action and the constitutional architecture of checks and balances. The first thing to understand is that the ruling is targeted but significant. It eliminates a specific and important claimed authority while leaving much of the administration's constitutional landscape intact. The emergency docket wins on immigration and other matters are not directly affected. The broader regulatory authorities that the administration exercises through normal administrative law channels are not affected. What is specifically and consequentially affected is the ability to use IEEPA emergency declarations to impose sweeping across-the-board tariffs on imports, one of the most powerful and most practically deployed unilateral tools in the second-term governing arsenal. The targeting of the ruling means it is not the comprehensive gutting of the presidency that the most dramatic version of the nuclear move framing might suggest. But the significance of what it actually targets means it is not a narrow technical correction with limited practical consequences either. It is a precisely aimed major ruling that eliminates a consequential executive authority. Exactly the kind of constitutional constraint that the nuclear move framing is most accurately applied to describe. The second thing to understand is what the ruling establishes as precedent for the court's approach to presidential emergency power claims in other domains, and why that precedential effect may ultimately be as significant as the specific tariff authority that the ruling directly addresses. The ruling establishes that the court will scrutinize the specific statutory authority being invoked in emergency power claims. That emergency declarations are not the end of the legal inquiry, but the beginning of it. and that the specific action being taken under the emergency declaration has to find genuine authorization in the statutory text being invoked. That principle applied to other emergency authority claims across other policy domains is a significant constraint on the administration's ability to use emergency declarations as the legal vehicle for implementing policy goals that would otherwise require the legislative process. If courts in other contexts apply the same analytical framework, looking past the emergency declaration to the specific statutory authorization for the specific action, the IEEPA tariff rulings implications extend well beyond trade policy. Immigration enforcement, energy policy, regulatory restructuring, all of these policy domains where the administration has claimed emergency authority could face similar scrutiny under the same constitutional framework. The emergency declaration is not an automatic justification for any executive action the president wants to take. There has to be specific statutory authorization for the specific action being taken. And if that authorization doesn't exist, the court will say so. That's a significant constraint on the entire emergency power governing strategy. The third thing to understand is the specific political and constitutional significance of the Republican split that the ruling generated, and what that split reveals about the long-term trajectory of constitutional conservatism in the Trump era. The Republicans who praised the ruling as a defense of Congress's constitutional authority were applying the constitutional methodology that the conservative legal movement has championed for decades. Textualism, originalism, fidelity to the specific allocations of power in the constitutional text. The Republicans who attacked the ruling as judicial overreach were prioritizing the administration's policy preferences over the constitutional methodology that conservative legal theory has traditionally embraced. That split is not a minor disagreement about the application of agreed constitutional principles. It is a fundamental disagreement about whether the constitutional principles that the conservative legal movement has championed apply consistently when they constrain a Republican president's preferred policy tools. And the specific answer that Roberts, Gorsuch, and Barrett gave, joining the 6-3 majority to apply those principles to constrain the administration, is the constitutional statement that the nobody saw coming framing is most accurately describing. The conservative justices applied conservative constitutional methodology to reach a conservative outcome in terms of constitutional interpretation, even though that outcome constrained executive power. That's what constitutional conservatism actually looks like in practice. Now let's talk about what this means for the immediate future of the Trump governing approach. The administration's immediate announcement of a new tariff order under a different statute tells us that Trump is not going to simply accept this constraint and move on. He's going to keep pushing, keep testing, keep finding workarounds. But each workaround comes with its own limitations. The alternative statute that Trump announced has a shorter sunset provision, meaning the tariffs under that authority will expire after a shorter period unless renewed. It may have more limited scope. It may face its own legal challenges. The administration is now operating in a much more constrained legal environment than it was before the IEEPA ruling. And the markets are watching all of this unfold with intense interest. The uncertainty created by the legal maneuvering, the back and forth between the administration and the courts. The question of whether any particular tariff order will survive legal scrutiny. All of this creates uncertainty for businesses, for investors, for international trading partners, and that uncertainty has real economic consequences. The nuclear move that the court made has set off a chain reaction that will continue to play out for months, if not years, as the administration, the courts, and the markets all process what just happened. The final thing to understand about the IEEPA tariff ruling and the constitutional confrontation it represents is why this specific kind of legal defeat, the targeted decisive rejection of a specific constitutional overreach by a 6-3 majority that included the president's own appointees, is the form of accountability that the rule of law is most specifically designed to produce, not a political decision by senators who can be pressured or threatened into loyalty. Not a criminal verdict that requires proof beyond a reasonable doubt of specific criminal intent. A constitutional judgment reached through the interpretive methodology that the court is constitutionally assigned to apply, finding that a specific claimed executive authority does not exist in the law the administration invoked to support it. The Supreme Court's 6-3 ruling that IEEPA does not authorize sweeping tariffs established permanent constitutional precedent that emergency declarations are not blank checks for presidential power, and it was authored by Trump's own appointee. The administration's immediate freakout, however genuine, cannot undo what the court said. The nuclear move landed, the constitutional landscape is permanently changed, and the clash between executive ambition and constitutional constraint continues to define this era.